Thank you. So we will now move to Group 13 on social housing. I call Amendment 101 in the name of Paul Sweeney, grouped with Amendments 304, 305, 337 and 338. I call on Paul Sweeney to move Amendment 101 and to speak to all amendments in the group. Mr Sweeney.
Thank you, Deputy Presiding Officer. May I initially declare an interest as a recently co-opted committee member of Reidvale Community-Based Housing Association in Glasgow. The purpose of Amendment 101 is to bring the legislation on housing into alignment with sections 109 to 113 of the Cooperative and Community Benefit Societies Act 2014. This would mean that registered social landlords can transfer engagements only if 2/3 of tenants vote in favour of a special resolution. To do so, currently a simple majority of tenants in favour is required to proceed through the process. Section 111 of the Cooperative and Community Benefit Societies Act of 2014, which governs shareholder voting in takeovers of societies and is legislation that applies across the UK, stipulates that a special resolution must be passed at a general meeting by at least 2/3 of the eligible members who vote. And I was motivated to lodge this amendment by what happened at Reidvale Housing Association last year. Had the measure in this amendment been in place then, the tenant ballot to transfer the association's stock would not have reached the threshold required for the proposal to proceed to the special general meeting of shareholders, at which the 2/3 majority requirement to transfer the engagements was not met. And that was only achieved after a last-ditch local campaign against a well-resourced propaganda effort by Places for People Scotland to try and seize control of the housing stock that was under community ownership. In December 2023, Reidvale Housing Association had proposed to transfer its housing stock of around 900 properties, valued at approximately £180 million at market value, to Places for People Scotland, but in a tenant ballot which was open for 32 days and in which 73% of tenants cast their vote, 62% voted in favour of the proposal. But had the 2/3 majority rule been in place, the proposal would have fallen at that point because it did not meet the threshold of 66.6%. As you may know, Reidvale Housing Association is one of Scotland's first community-based housing associations, and it was formed after the seminal Housing Act of 1974, which is now celebrating half a century of community-based housing. And indeed, the Forum in the West of Scotland of Community-Based Housing Associations did highlight that they had serious concerns about the pattern of transfers and engagements of those community-based housing associations over the last few years, and that in cases where they have taken place, they have largely had the support of over 90% of tenants, and that the only one that fell below 90% level, which was for the Pineview Housing Association and Kendoon Housing Association transfer, was unusual. So clearly there were instances where the housing association support from tenants has fallen below that threshold. There is concerns. So in instances where transfers of engagements are sought, they should really enjoy the support of the vast majority of tenants for the proposition to be reasonable. And with yes votes and transfer belts normally exceeding that 90% threshold, it was clear that there was a concern in Reidvale's case, because almost 40% of voting tenants opposed the transfer, despite the enticing offer of a 5-year rent freeze to hand over the £180 million of housing stock that they collectively owned. That was hardly a resounding vote of confidence. So I think the requirement for a supermajority, which would require support from 2/3 of the tenant body, would make it clear that there is a settled majority view on what would be the best future for one of Scotland's community-based housing associations. After all, it is a one-way road from being a community-based association to joining one of the large national housing groups. And there's never been a case in Scotland where a large national housing group has spun out a small community-based housing association. So I think this amendment is important in order to protect the sector. And I think also it's important to note that once it had the required tenant approval, the transfer, which was in place by a small majority, Reidvale Housing Association wanted to hold that special general meeting with its shareholders on the 16th of January last year in order to seek ratification, and it was then voted down. And the chair of the Glasgow and West of Scotland Forum of Housing Associations at that time said that, as an obvious supporter and promoter of community-based housing associations, they welcomed that decision by the shareholders and recognised the concerns expressed by members, including the impending loss of community assets and the inevitable disappearance of local decision-making. This is why I think that this amendment is reasonable and coherent. It proposes the prudent measure of bringing the voting threshold for tenants and shareholders of housing associations into alignment with a two-thirds threshold for both. That would serve to provide an extra layer of protection and confidence for community-controlled housing associations against what are often cynical and insidious attempts to railroad through irreversible takeovers of community-controlled assets and risk pitting tenants against the member shareholders, which has been a worrying trend in Scotland's housing sector in the past few years, of which Reidvale Housing Association is just the latest and most egregious example. It would be particularly fitting for the Parliament to support
Mr Sweeney,
this
could you bring your
amendment,
mic to close, please?
because this year marks the 50th anniversary of Scotland's first community-based housing associations, and I will speak to the remainder of my amendments in my closing. Thank you.
Mr Sweeney, could you move Amendment 101, please?
Oh, with pride. Thank you.
Thank you very much. I now call Mark Griffin to speak to Amendment 305. And before I do that, I must do something else, which is to advise members that they will note that we will shortly reach the next time limit, and we have a further group still to debate. Under Rule 9.8.5a, I am minded to accept a motion without notice to propose that the time limit be extended by 30 minutes. I invite the Minister for Parliamentary Business to move.
Move, Presiding Officer.
Thank you, Minister. The question is that the time limit for debate on amendments be extended by 30 minutes. Are we all agreed? The Parliament is agreed. I now call Mark Griffin to speak to Amendment 305 and other amendments in the group. Mr Griffin.
Thank you, Presiding Officer. Before I start on my own Amendment 305, I just want to take this opportunity to express my support for the amendments in the name of Paul Sweeney and Ariane Burgess in this grouping, which promote cooperative and community-based housing models. On Amendment 305, this amendment ensures that families aren't prevented from moving to accommodation that better meets their needs simply because of outstanding housing arrears or related debts. This is a targeted and compassionate reform. It doesn't prevent local authorities or social landlords from recovering those debts, but it does remove a barrier that too often traps families in unsuitable homes. We know from casework and from the experiences of advocacy organisations like Aberlour that families on low incomes can find themselves stuck in overcrowded, unsafe or inappropriate housing, unable to move because of historic arrears. This situation can then deepen the hardship, undermine family well-being and make it even harder for people to break the cycle of debt and disadvantage. Presiding Officer, purely by chance, I received an email yesterday from someone who thought I was their MSP, but I'm actually not. They're a constituent of the Rutherglen constituency. But the email did saying, I'm a constituent living in Rutherglen constituency in a small two-bedroom flat with my partner and our 4 children. So a partner and 4 children in a small two-bedroom flat. Severely overcrowded. Our families currently living in conditions that are overcrowded and severely impacting our mental health and well-being. We've been on the transfer list since 2017. We got into arrears during COVID and had our application suspended for a long time without us even being notified, which set us back a long way. Now, like I said, receiving that email from someone who thought I was their MSP purely by chance highlights exactly the situation that I'm trying to avoid, that families who are overcrowded, children whose mental health and health has been impacted by being in an overcrowded house because of arrears that are entirely out with their control, shouldn't stop them from being moved to a house that properly meets their needs. And like I say, this amendment doesn't stop a local authority or a social landlord from recovering that debt at a later stage, but allows us to treat that family with empathy and give them the home that they need. And so ask members to support Amendment 305.
Thank you, Mr Griffin. I now call Ariane Burgess to speak to Amendment 337 and other amendments in the group. Ms Burgess.
Thank you, Presiding Officer. And before I speak, I just want to apologise for arriving slightly late into the chamber for this grouping. I also want to note, before I speak to my amendments, that I will be supporting Paul Sweeney and Mark Griffin's amendments for the same reasons that they support community and cooperative housing. Amendment 337 would require the Scottish Housing Regulator to have regard to different models of social housing, such as housing cooperatives. At present, the regulator adopts a blanket approach to all forms of social housing, and this system does not take into account that social housing comes in a variety of models. So regulations that rightly apply to one form of housing can be to the detriment of other forms. And this particularly disadvantages forms of housing such as cooperatives. I've spoken with several co-ops and they find that the regulator doesn't fully understand the model. It also expects them to operate in the same way a major housing association might when they don't have that level of resource available to them. And this means that what may be a simple single step for a typical housing association translates into a complicated process for a registered social landlord cooperative. And this simply isn't fair. These co-ops routinely deliver high levels of tenant satisfaction and prove time and time again that they can operate effectively as social landlords. We are now at a point where the number of RSL co-ops in Scotland has tumbled from 20 to just 7 in the space of 2 decades. So where on the one hand the regulator is performing its duty to protect tenants, homeless people and others, on the other hand it's depriving these same people from a form of housing that could make a significant positive difference to their lives. This amendment, which has been drafted with the support of Co-ops UK, is reasonable in its scope and is within the spirit of the Housing Scotland Act 2010, which sets out the regulator's obligations. It's worded in a way that does not place cooperatives above other forms of social housing, and nor does it seek to be overly prescriptive in what it requires of the regulator. But it will mean that the housing regulator has to make a slightly different approach to governance. And by passing this, we could create a culture of supporting cooperatives in the social sector to flourish and provide more options for people when it comes to affordable social housing.
Thank you, Ms Burgess. I now call the Cabinet Secretary.
Presiding Officer, I shall begin with Amendment 101 in Mr Sweeney's name. The Government's position on this has not changed from Stage 2. The Housing Scotland Act 2010 sets out that for a transfer to proceed, a majority of tenants should agree to it. I wasn't initially clear on the rationale for this, but I have listened carefully to what Mr Sweeney has said. But moving to a requirement for two-thirds of tenants, I fear this could be viewed as setting out a position where the expressed wish of a simple majority of tenants could be ignored. Moreover, having looked into the matter, it appears that 21 transfers out of a proposed 22 since 2010 have all received approval by well over two-thirds of tenants, indicating, I think, that there isn't a great case for change to be made. And then coupled with the fact that there's been no consultation with the sector, either landlords or tenants, and a questionable bit of a paucity of evidence for the need for change, given that all those transfers since 2010 have received well over two-thirds majority, I won't be supporting this amendment. But I'll move to Mr Sweeney's Amendment 304, which is seeking to require the... Yes?
Briefly, Mr Sweeney.
Does the Cabinet Secretary not agree that having the two-thirds majority of shareholders in the 2014 Act is justified? And also, does the Cabinet Secretary not accept that the attempted asset stripping of £180 million of community housing is something that should be of concern to the Government?
Cabinet Secretary.
Well, of course that may or may not be a concern to the Government, and I'm happy to speak to Mr Sweeney about that some more. But the question that's in front of me just now is whether a change to primary legislation is required. And if I can look and see that 21 transfers out of 22 proposed since 2010 have all received approval by well over two-thirds of tenants, I don't think there is a case for change. I'll take one more intervention.
Briefly, Mr Mason.
Cabinet Secretary for giving way. I mean, would she agree with me that it was very unfortunate to use a term like asset stripping in that case? Places for People are a reputable association. They are seeking to help the people of Reidvale. The jury is still out as to whether Reidvale can survive on its own.
Cabinet Secretary.
Presiding Officer, it's clear that this is a matter which Glasgow representatives are very well acquainted with the detail of, and given that I'm not, I'm going to be careful not to use or endorse any of the terms, but if either member wants to speak to me about it more, I'll be very happy for them to do so. But on Amendment 304, this is seeking to add to the requirement for the Scottish Housing Regulator when it's performing its regulatory functions, requiring them to encourage a diversity of social housing models, including cooperatives. this sounds absolutely fine, but the regulator does not differentiate at all between different types of registered social landlords in their work, and this amendment would present a change to their functions. It would also present technical challenges, as housing cooperatives are not defined in the 2010 Act. So I am sympathetic to the intention, namely the promotion of cooperatives. I'm very supportive of cooperatives, but imposing this loosely defined additional duty under the Scottish Housing Regulator's general function, I think presents a challenge that we ought not to take on. Yes, I will do.
Briefly, Mr Sweeney.
Does the Cabinet Secretary not agree that in the context of having ostensible neutrality, inevitably the bigger housing associations will dominate the smaller ones, and that there should be positive protections in place?
Cabinet Secretary.
On the contrary, I think it's important that when the regulator is carrying out its regulatory functions, that it's allowed to do that without the drawing out of one type of registered social landlord or another. However, that's not to say that the promotion of cooperatives can't be done in an alternative way, and I'd be very happy to work with him on that. Moving to Mr Sweeney's Amendment 338, requiring a transfer of assets of an RSL to a community-based housing association operating in the area where there's been misconduct, mismanagement or landlord viability is in jeopardy, as his amendment would have it. My concern with this is that it would be overly restrictive. It wouldn't take into account the financial or organisational ability of the other community-based RSLs in the area, or indeed their views in terms of whether or not they wish to take on the assets of another RSL that is failing, and therefore, ultimately, it may not be in the best interests of tenants, existing tenants, for that to go ahead. In addition, legislation already requires that before directing a transfer of assets, the Scottish Housing Regulator may consult tenants affected by the transfer and any secured creditors. And furthermore, an RSL may already request that the regulator direct a transfer of its assets to another specific RSL. So the provisions exist, but they do so with the relevant safeguards that I think are required. Turning to Amendment 305, which I absolutely appreciate is intended to support tenants with rent arrears to obtain a mutual exchange, the provision would go further, much further than that, and it would prevent a landlord refusing consent for a mutual exchange on the basis of rent arrears where the criteria that Mr Griffin has set out in his amendment are satisfied, and there are a number of criteria. This would apply regardless of the total amount of rent arrears or whether the tenant was currently paying the rent arrears or keeping to a repayment plan. In fact, the only situations where the landlord could refuse consent would be where notice of proceedings had already been served on the tenant on conduct grounds, or an eviction order, I will do in a wee sec, an eviction order had been granted against the tenant for the current tenancy. I'll take the intervention.
Briefly, Mr Griffin.
Yeah, I appreciate the Cabinet Secretary's position, but surely the Government must accept that the children in an overcrowded property who didn't contribute to the arrears, the quantum of those arrears, whether there's a repayment schedule, it isn't the fault of those children, and they should be given the opportunity to move to a house that meets their needs, regardless of the debt that's been incurred by those that weren't them.
Cabinet Secretary.
Of course, I absolutely appreciate that. And in respect of the case that Mr Griffin raised with the Chamber, I'm sure that Claire Hockey, as the constituency representative for Rutherglen, will be very glad to take that up, and she will be able to point to the family to the fact that social landlords already have discretion to agree a mutual exchange between their properties where there are rent arrears, and in fact that this bill already contains measures for social landlords to take action to support tenants with rent arrears arising in particular in the bill from domestic abuse. Finally, Presiding Officer, Ariane Burgess' Amendment 337 would add a requirement on the Scottish Housing Regulator when preparing, revising or withdrawing guidance to have regard for a range of different housing models, including cooperative models. And again, much with Mr Sweeney, I absolutely appreciate the intent behind this amendment, but it doesn't operate as intended, I'm afraid, in the context of the regulator's guidance as to how it will assess each social landlord's progress towards meeting the relevant standards. This is about, again, the fact that in carrying out its regulatory function, the housing regulator does not have a role in promoting one type of housing over another. But as I noted to Mr Sweeney, I am very supportive of cooperatives. I had an excellent meeting with Granton. I saw the wonderful work that they were doing, and I would be pleased to continue working with Ms Burgess and Mr Sweeney on how we, as a Parliament and as how the Scottish Government might support them.
Thank you, Cabinet Secretary. And I call on Paul Sweeney to wind up and to press or withdraw Amendment 101. Mr Sweeney.
Well, it's again disappointing that the Government is not minded to support these amendments, and it's also disappointing that I've had no engagement whatsoever with the Government to try and reach a point of consensus on this, particularly when Scotland is celebrating half a century of community-based housing associations, that the sector is being snubbed by the Government in this way. I think it's important to recognise that the settled... Yes, happy to give way.
Cabinet Secretary, briefly.
Presiding Officer, with the greatest respect to Mr Sweeney, I just want to make sure that it's on the record to say that I have been engaging extensively with members over the summer, and I've had a number of engagements with the Scottish Labour Party. Generally, some members have been more able to meet than others.
Mr Sweeney.
Well, unfortunately, that invitation wasn't extended to myself. But I would say I was very keen to work across the chamber to reach consensus on this, and it was not forthcoming. And indeed, this amendment and these amendments do have the support of the cooperative sector and the community-based housing sector in Scotland. And I think it is important to recognise there are valid and genuine concerns which have not been heard clearly by the Government today or in the course of this legislation. We need proactive support to protect community-based housing associations that are clearly vulnerable to takeovers by large national housing groups. We clearly need proactive supports to sustain housing cooperatives in Scotland, which are actively being chastised by the regulator by saying that having restrictions on committee membership restricted to just tenants isn't good enough. So when it's recognised actually broadly when transfers do take place as well, that they enjoy that supermajority support, when they don't enjoy supermajority support, that should be a red flag. That should be a matter of concern, and that bringing the threshold up to two-thirds clearly is a prudent and benign measure to ensure that we don't have another Reid Vale Housing Association situation where the community has to essentially fight a rearguard action to save its community-owned housing association stock. And similarly, when faced with a transfer of engagements, priority, I think, should be given to ensuring that community-based housing stock goes to another community-based housing association in the first instance. If that doesn't prove to be viable or appropriate, then it could be opened up to a wider opportunity for national housing groups. But I think that's a bit of a sliding scale. It's not creating some sort of lockout for national housing groups if it's appropriate. So I think these are all very reasonable measures, and it would have been of great benefit to the sector, and I would have enjoyed greater opportunity to engage in this. But it seems like this sort of changeover of ministers has militated against that, and it's just very unfortunate that we can't do something with it in this legislation.
Mr Sweeney, could you confirm whether you're pressing or withdrawing Amendment 101? I
would like to press
Thank you. The question is that Amendment 101 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Richard Lochhead.
I'd vote no, please.
Thank you, Mr Lochhead. Your vote will be recorded. Thank you. The result of the vote on amendment number 101 in the name of Paul Sweeney is yes 24, no 80. There were no abstentions. The amendment is therefore not agreed. I call amendment 13 in the name of Maggie Chapman, already debated with amendment 9. Maggie Chapman, to move or not move?
Moved.
Moved. The question is that amendment 13 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 13 in the name of Maggie Chapman is yes 25, no 80. There were no abstentions. The amendment is therefore not agreed. I call amendment 14 in the name of Maggie Chapman, already debated with amendment 9. Maggie Chapman, to move or not move?
Not moved.
Not moved. I now call amendment 102 in the name of the Cabinet Secretary, already debated with amendment 9. Cabinet Secretary, to move formally?
Moved.
Thank you. The question is that amendment 102 be agreed to. Are we all agreed? No. Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 102 in the name of the Cabinet Secretary is yes 59, no 47. There were no abstentions. The amendment is therefore agreed. I call amendment 103 in the name of the Cabinet Secretary, already debated with amendment number 9. Cabinet Secretary, to move formally?
Moved.
Thank you. The question is that amendment 103 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 103 in the name of the Cabinet Secretary is yes 53, no 51. There were no abstentions. The amendment is therefore agreed. The question, I now call amendment 214 in the name of Edward Mountain, already debated with amendment 9. Edward Mountain, to move or not move?
Not moved.
Not moved. I call amendment 104 in the name of the Cabinet Secretary, already debated with amendment 9. Cabinet Secretary, to move formally?
Sorry, moved.
Thank you. The question is that amendment 104 be agreed to. Are we all agreed? Yes. Are we all agreed? Yes, the Parliament is agreed. I call Amendment 215 in the name of Edward Mountain, already debated with Amendment 9. Edward Mountain, to move or not move?
Moved.
Moved. The question is that Amendment 215 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 215 in the name of Edward Mountain is yes 46, no 59. There were no abstentions. The amendment is therefore not agreed. I now call amendment 216 in the name of Edward Mountain, already debated with amendment 9. Edward Mountain, to move or not move?
Sorry, Presiding Officer, I didn't. Was it 216?
216.
Not moved.
Not moved.
Presiding.
Thank you. I call amendment 217 in the name of Edward Mountain, ready to debate with Member 9, and Edward Mountain has indicated he is not moving. He's ahead of me. And that is on amendment 217. I call amendment 15 in the name of Maggie Chapman, already debated with amendment 9. Maggie Chapman, to move or not move?
Moved.
Moved. The question is that amendment 15 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 15 in the name of Maggie Chapman is yes 23, no 82. There were no abstentions. The amendment is therefore not agreed. I call amendment 218 in the name of Edward Mountain, already debated with amendment 9. Edward Mountain, to move or not move?
Moved.
Moved. The question is that amendment 218 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 218 in the name of Edward Mountain is yes 39, no 66. There were no abstentions. The amendment is therefore not agreed. I call amendment 219 in the name of Edward Mountain, already debated with amendment 9. Edward Mountain, to move or not move?
Moved.
Moved. The question is that amendment 219 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 219 in the name of Edward Mountain is yes 24, no 82. There were no abstentions. The amendment is therefore not agreed. We now turn to Group 14 on tenancy deposits, premiums and guarantors. I call Amendment 45 in the name of Maggie Chapman, grouped with amendments as shown in the groupings. And I call on Maggie Chapman to move Amendment 45 and to speak to all amendments in the group. Ms Chapman.
Thank you, Presiding Officer, and I move Amendment 45 in my name. This amendment requires Scottish ministers to reduce the maximum deposit allowed. As deposits are usually linked to rents, as rents have increased, so have deposits. The average rent for a two-bedroom flat in Lothian is £1,358 per month. And as landlords can ask for up to 2 months' deposit, a maximum deposit would be around £2,700. Scottish renters, which the Cabinet Secretary has repeatedly said enjoy more protections than in England, can already be charged much higher deposits than their English counterparts, who can be charged no more than 5 weeks in most cases. That change to 5 weeks was introduced by the Conservative Government's Tenants' Fees Act 2019 and voted through by Labour, Lib Dem and Conservative MPs. I hope, again, maybe in vain, but I hope to see some consistency that their MSP counterparts won't deny their constituents that same right. Generation Rent has conducted surveys with tenants and found that high deposits can cause serious issues with being able to afford to move, even when moving is essential. One tenant described needing to move for their partner's mental health, but not being able to. They said, "We really needed to move, but we couldn't because the deposit was the big sticking point. You can fiddle about with some of the other costs, but having to have that deposit up front, as well as the next month in advance, it was just too much." Presiding Officer, tenants face significant financial pressures at the beginning of a tenancy, with rent deposits and other moving costs contributing to higher upfront costs. In our survey, tenants were asked how they met these costs at the beginning of their current tenancy. Nearly a third, 32% of respondents, had to dip into their savings to cover their expenses, while a quarter had to borrow money from friends or family. For 14% of tenants, credit became a lifeline to affording the deposit, whether through credit cards, overdrafts or loans. High deposits also place pressure on discretionary housing payments. I'm proud that Greens have successfully campaigned for more DHP funding, but higher deposits are taking up funding that can easily be redirected to other pressing needs if the maximum deposit is reduced. I'll now speak briefly to some of the other amendments in this group. Megan Gallagher's Amendment 290 would require deposits to be paid directly to a deposit protection scheme. This would set up a direct line of communication between tenant and scheme and make it easier for deposits to be returned. Ross Greer will speak to his amendments, so I won't speak to them now. So to close, Presiding Officer, we have another opportunity here to improve people's access to housing and to improve Scottish tenants' rights to match those elsewhere in the UK. I hope members across the chamber can support that and vote for my amendment. Thank you.
Thank you, Ms Chapman. I now call on Megan Gallagher to speak to Amendment 290 and other amendments in the group. Ms Gallagher.
Thank you very much, Presiding Officer. For the benefit of all members in the chamber, I am not going to press Amendment 290 as I have identified an issue and a concern with the drafting of Amendment 290, so therefore I will not be pressing. In terms of Amendment 45 that Maggie Chapman has submitted, if I can speak on this incredibly briefly, as I do believe that lowering the deposit cap is unnecessary and it could leave landlords less protected against arrears, damage to property, and it could also undermine the sector. So for that reason, the Scottish Conservatives will not be... Yes, I will.
Briefly, Maggie Chapman.
Can I thank Megan Gallagher for taking my intervention? Can she explain why exactly this provision, 5 weeks deposit, was introduced by her own colleagues elsewhere in the UK? Why won't she back it?
Megan Gallagher.
Well, look, we're discussing this amendment. We're not discussing decisions that have been taken elsewhere. And I think when we're actually looking at balance, parity of the sector, we've got to be reasonable in terms of the amendments that we're bringing forward. I don't think we can undermine the confidence in the sector any more than it's already been undermined because of decisions that have been taken through the housing bill up to this point. And I do believe that amendments such as this will lead to more landlords leaving the sector. And what we do need actually is a stable, a predictable deposit scheme. That is good for maintaining landlord confidence, and we will be reflecting that in our votes this evening in terms of what we will be voting for.
Thank you, Ms Gallagher. I would take this opportunity of advising members that as we are nearing the agreed time limit under Rule 9.8.4a, open brackets, small c, close brackets, I consider it necessary to allow the debate on this group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. And with that, I call Ross Greer to speak to Amendment 291 and other amendments in the group. Mr Greer.
Thank you, Presiding Officer. I'll try to reasonably curtail myself in the interest of time. Amendments 291 and 292 are alternative options to achieve the same aim, a guarantor scheme for people who are estranged from their families. 379 is a consequential amendment to either or both of those. 291 would require ministers to create a scheme where a public body, so a council or a university, is to act as the guarantor for a young person who is estranged from their family, supporting them with access to private tenancies. 292 is an attempt at compromise. It was drafted to reflect points raised by the government at stage 2, particularly around the need for consultation and their hesitance around specific bodies acting as guarantors. So 291 says ministers must create a guarantor scheme for estranged young people. 292 replaces must with may, giving ministers the power to do so but not compelling them to use it. The government has recognised the significant barriers that estranged young people face in accessing housing, so it's disappointing they aren't backing these options. Instead, the Cabinet Secretary announced yesterday that we're getting another mapping exercise, and I've got to say I felt utterly deflated hearing that. How many times does the government need to ask the same question, gather the same evidence and form the same working groups? The government commissioned research on this. It was published 3 years ago into the barriers affecting estranged young people in further and higher education. That said, the implementation of a national guarantorship scheme was recommended to assist estranged students access accommodation more easily. End quote. We know that for many young people and students, it can be difficult to get landlords and letting agents to take them on, and they often require guarantors as a form of security. It's obvious that most people in that situation turn to older family members to step in as those guarantors. Those who don't have family that they can turn to due to estrangement are at a significant disadvantage, making it even harder to access housing and compounding the huge challenges that they already face. We know the landscape's uneven right now. Some universities, like Glasgow, have generous and comprehensive support packages, including guarantorship schemes. In Glasgow's case, that's due to the campaigning work from their former student and now the councillor for the area, Blair Anderson. But other institutions have no arrangements in place at all. The government's already looked at this in this session and been told to act. This was a Butte House Agreement commitment, and being completely honest, the reasons that were given to me by some within the government for not taking it forward over the last few years were tenuous, verging on nonsensical. The financial costs are completely negligible for a start. It's a sad reality that for some young people, moving away from home for the first time for university or another reason is the first opportunity to escape an abusive family or home situation. Guarantor requirements act as a massive barrier to that, and they often allow abusers to maintain a position of power over young people into their adult life. This small step would make a transformational impact for a vulnerable group in our society who are at far higher risk of homelessness than most of us. If members agree on the principle of that, but still have specific concerns, which we don't have time to discuss today, which mean they can't support 291, I urge them to support 292 to give ministers the clear power to set up such a scheme in the future once the government's concerns have been addressed. Thank you.
Thank you, Mr Greer. I call on Edward Mountain to speak to Amendment 223 and other amendments in the group. Mr Mountain.
Thank you very much, Presiding Officer. The point of these amendments are to try and make sure that unclaimed deposits are used properly and not allowed to sit and fritter away. Just a little bit of information. I think the Parliament would be surprised, Presiding Officer, that in November 24 there were 23,123 unclaimed deposits sitting with Safe Deposit Scotland, which totalled £10,182, for which they are getting the interest, which probably assumes that they're getting about £300,000 a year. Now, this is the sort of money that's sitting there, and the government, by their amendments, want to take it and use it to inform private tenancies or tenants in private tenancies about the obligations and about the bill. I don't want to do that. I think that money should go into social housing and to be used to increase and improve the standard of social housing and allow the people who are renting in that sector to benefit from this £6 million pot. My amendments 225, 224 and 223 and 227 are all technical amendments to allow that to happen. And I do believe that that should get the support of the Parliament. I'll be surprised if it doesn't, Presiding Officer. Talking to Amendment 45, I listened to Maggie Chapman's point. Sadly, she bases all her decisions on rents in urban areas. Rents in rural areas are much lower and could be as low as £700 a month. So 2 months' rent, £1,400. In my mind and my experience, that would allow for just one room in one house to be repainted and recarpeted if there are any damage at the end. That seems entirely reasonable. If the amendment had been shifted around to suggest that higher rents was at a percentage rather than catching all the lower rents, it would have made sense. I'm interested, Presiding Officer, in Ross Greer's amendments. I thought that was interesting, and I hadn't really looked at it from that point of view. And I'd be interested to see what the Cabinet Secretary says in response for it. And I think when we come to Mark Griffin's amendments, I strongly agree with you, Mr Griffin. There are other things sometimes that are included within the rent, which we know about. For example, private water supplies and private sewage may be included in the rent figure, but it's not the rent for the house. It's the money probably that's equivalent to what Scottish Water would be charging, which we're told is so reasonable for disposal of waste. So, Presiding Officer, I'd be interested to hear what the Cabinet Secretary says, and I'm sure the Parliament will support my amendments to make sure the money goes into social housing, where it should be spent. Thank you.
Thank you, Mr Mountain. I now call on Mark Griffin to speak to Amendment 391 and other amendments in the group. Mr Griffin.
Thank you, Presiding Officer. These amendments 391 392 are about delivering clarity, fairness and transparency for tenants across Scotland's rental sector. At present, there is a lack of consistency in how rent and service charges are defined and reported, and that can leave tenants confused about what they're actually paying for, and it makes it difficult to compare properties or challenge unfair charges. These amendments would make it explicit that charges for domestic services such as water, sewerage, gas, electricity, broadband and district heating are not to be treated as premiums and must be kept separate from rent. Now, this isn't purely a technical change. It has real-world consequences for tenants, letting agents and rent officers. Too often, published market rents obscure whether utilities are included, making it impossible for tenants to know if they are being charged fairly or to make meaningful comparisons between properties. That lack of transparency can undermine trust in the sector and can leave tenants vulnerable to hidden costs. By clearly separating occupancy costs from service charges, these amendments provide complete transparency to everyone involved. It empowers tenants to understand exactly what they are paying for, supports rent officers in their regulatory role and ensures letting agents operate on a level playing field. Now, ultimately, clarifying that rent means rent in this bill and is not bundled with service costs will help create a more open, accountable and fair rental market. It will support accuracy in the open market, protect tenants from unfair practices and build trust in the system. Now, I understand that it is the Government's position that they already believe that the definition of rent premium doesn't apply to the charges for these essential off-main services, and so I would ask if the Cabinet Secretary, I would be grateful if the Cabinet Secretary could confirm that in the record if that is in fact the case, and potentially issue guidance to give clarity for the sector if the Government felt that was appropriate, and if that was the case, would not plan on moving amendments 391, 392. Thank you.
Thank you, Mr Griffin. And I call the Cabinet Secretary.
Thanks, Presiding Officer. I'll begin with Amendment 45 in Maggie Chapman's name, which would require existing regulation-making powers to firstly specify the maximum amount of deposit and secondly impose a restriction so that the amount must be less than the current maximum 2 months' rent. I listened very carefully to Maggie Chapman and I do absolutely understand her intent. I can't support these, however. These amendments would restrict the ability of ministers to bring forward draft regulations for approval by Parliament that allow for appropriate tenancy deposits following consultation with landlords and tenants. We've committed to consult on conditions for approval as part of implementing the new right of tenants to seek consent to keep a pet, including the potential for a supplementary pet deposit. So it wouldn't be right to restrict future changes. If this is the right course of action, then it will be borne out in the discussions we'll be having with tenants and landlords. And I have to say, it is also worth noting that sometimes in restricting rents that can be made available, we can have unintended consequences whereby landlords look for other means in order to secure or have security over their contract with the prospective tenant. I won't speak to 290. Megan Gallagher has confirmed she's not pressing, so I'll turn to Ross Greer's amendments 291, 292 and 397, seeking to establish a rent guarantor scheme for estranged young people through regulations. I understand the concerns behind these. I've met with Mr Greer and discussed them with him. I'm very sympathetic to the outcomes that are sought, but I don't believe that either of the options put before us are appropriate. Firstly, conferring functions on a public body to act as a guarantor, I am not being convinced just now, I have not been convinced that this is the best way to support estranged young people, particularly in view of the additional costs and time that it could take to set up such a new scheme. Consideration would also have to be given to whether on how to describe estranged young people in an appropriate way. And perhaps most importantly, it hasn't been clear to me in the discussion of these matters why it would be readily justifiable to pursue provision for one group, i.e. estranged young people, to the exclusion of all others who may need support with guarantees. So, as he said, I know he has his doubts about it, but it's important that we do this work. A mapping exercise is currently underway to identify gaps and barriers in guarantor provision, and doing so across the board. Early findings do show an inconsistent support and a lack of clear pathways, so once this work is complete, my intention is that it will form a more consistent and accessible approach, potentially through national guidance or a framework. And I commit today to progressing this work to improve access to rented accommodation for estranged young people, as well as others who may require support. And I'll take an intervention.
Ross Greer, briefly.
I'm grateful to the Cabinet Secretary for taking the intervention. My frustration with that work is that work was already done in 2022. The Government published it in 2022. The argument that she makes about not being convinced about public bodies as guarantor schemes, I disagree, but I accept that's the Government's position. That's an argument against 291. I'm still unclear as to why the Government opposes 292, which doesn't specify public bodies and doesn't say that the Government must set up this scheme. It simply gives them the power to do so if, for example, the mapping exercise results in the conclusion that that's what's necessary. Why would the Government not want the option of doing that at a later point without the compulsion to do so?
Cabinet Secretary.
Firstly, Presiding Officer, the work is underway. I don't need primary legislation in order to have that be the case, but I would also draw out that other point, which I think is very important and we mustn't lose sight of, which is how do we justify pursuing a scheme for estranged young people to the exclusion of others. The work that I'm undertaking and what the Government's been undertaking is much broader than that, and the results of it, therefore, could in turn be much broader. I'll turn to Edward Mountain's amendments 223 to 227, seeking to change the purposes for which unclaimed tenancy deposits could be used. A similar amendment was lodged at stage 2. We made clear then what I'll make clear today, which is that unclaimed tenancy deposits, these are sums that have been paid by private tenants, and we believe they should be used to benefit private tenants and those seeking to access the private rented sector. So I can't support them. Amendments 391 and 392 have cropped up a few times throughout Stage 3, and for the reasons that I've set out before, I can't support them. Mr Griffin knows that I don't support the changes to remove utility payments from the definition of rent payable, not least because this takes those payments out with protections that might otherwise accrue to rent and could leave tenants open to abuse of that provision. And I will leave it there, Presiding Officer.
Thank you, Cabinet Secretary. And I call on Maggie Chapman to wind up and to press or withdraw Amendment 45. Ms Chapman.
Thank you, Presiding Officer. I'll just restrict my remarks to that issue on guarantors, because yesterday I proposed a guarantor scheme for international students, for students who won't have the family support networks and others that are usually relied on for guarantors. This evening, Ross Greer has called for a guarantor scheme for estranged students, or for the powers to enable the government to set one up, should it so wish. And I think the idea that we can keep going over the same ground, repeating the same calls for evidence and getting the same answers time and time again is really, really frustrating for especially young people and students who have been looking for a solution to this problem for years. This isn't a new problem. The government itself identified it and had a report with very, very clear recommendations, but 3 years ago. And I do find it deeply frustrating that we are back in the same place, looking for more evidence of something we know very, very well is necessary. With that, Presiding Officer, I press Amendment 45.
Thank you, Ms Chapman. So the question is that Amendment 45 be agreed to. Are we all agreed? The Parliament has not agreed. There will be a division, and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 45 in the name of Maggie Chapman is yes 7, no 98. There were no abstentions. The amendment is therefore not agreed. I call Amendment 220 in the name of Maggie Chapman, already debated with Amendment 123. Maggie Chapman, to move or not move?
Moved.
Moved. The question is that Amendment 220 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 220 in the name of Maggie Chapman is yes 44, no 61. There were no abstentions. The amendment is therefore not agreed. I call Amendment 221 in the name of Edward Mountain, already debated with Amendment 123. Edward Mountain, to move or not move?
Move.
Moved. The question is that Amendment 221 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 221 in the name of Edward Mountain is yes 40, no 66. There were no abstentions. The amendment is therefore not agreed. I call amendment 290 in the name of Megan Gallagher, already debated with amendment 45. Megan Gallagher, to move or not move? Not moved. Thank you. I now call amendment 222 in the name of Maggie Chapman, already debated with amendment 123. Maggie Chapman, to move or not move?
Moved.
Moved. The question is that amendment 222 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 222 in the name of Maggie Chapman is yes 7, no 99. There were no abstentions. The amendment is therefore not agreed. I call amendment 291 in the name of Ross Greer, already debated with amendment 45. Ross Greer, to move or not move?
Not move.
Not moved. I call amendment 292 in the name of Ross Greer, already debated with amendment 45. Ross Greer, to move or not move?
Move.
Moved. The question is that amendment 292 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 292 in the name of Ross Greer is yes 9, no 96. There are no abstentions. The amendment is therefore not agreed. I call amendment 223 in the name of Edward Mountain, already debated with amendment 45. Edward Mountain, to move or not move?
Moved.
Moved. The question is that amendment 223 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 223 in the name of Edward Mountain is yes 22, no 68. There were 16 abstentions. The amendment is therefore not agreed. I call amendment 224 in the name of Edward Mountain, already debated with amendment 45. Edward Mountain, to move or not move?
I've got to move it, Presiding Officer.
Okay, thank you. The question is that amendment 224 be agreed to. Are we all agreed? Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 224 in the name of Edward Mountain is yes 23, no 67. There were 16 abstentions. The amendment is therefore not agreed. I call amendment 225 in the name of Edward Mountain, already debated with amendment 45. Edward Mountain, to move or not move?
Not moved.
Not moved. I now call amendment 226 in the name of Edward Mountain, already debated with amendment 45. Edward Mountain, to move or not move?
Moved.
Moved. The question is that amendment 226 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 226 in the name of Edward Mountain is yes 47, no 59. There were no abstentions. The amendment is therefore not agreed. I call amendment 227 in the name of Edward Mountain, already debated with amendment 45. Edward Mountain, to move or not move?
Not moved.
Not moved. I now call amendment 228 in the name of Graeme Simpson, already debated with amendment 3. Graeme Simpson is joining us online. I would ask him to move or not move.
Not moved.
Not moved. Thank you, Mr Simpson. So we now move to Group 15 on landlord registration. I call amendment 229 in the name of Maggie Chapman in a group on its own, and I call on Maggie Chapman to move and to speak to amendment 229. Thank you.
Thank you, Presiding Officer. And I move amendment 229. Yes, 229 in my name. Several times during the passage of this bill, I have talked about the need to ensure there is proper incentive for rent controls to be respected by landlords. Without this, they will be weakened, just like rent pressure zones were. That's why we argued for higher fines, and Amendment 229 ensures that any landlord who has been charged an illegal rent, any landlord who has charged an illegal rent increase or wrongfully ended a tenancy will have these taken into account by the local authority when deciding whether they are a fit and proper person to be renting out property in their area. Importantly, this amendment does not require local authorities automatically to strike off landlords for the reasons outlined in the amendment. It only requires that they consider these when assessing whether they are fit and proper. If there are mitigating circumstances why the rent was inappropriately increased, then those can be explained by the landlord and considered. So there are safeguards in place in this amendment. But 229 puts some important teeth into the bill. It makes clear that rent controls should be respected and ensures that there are appropriate penalties if they are not. I ask the Chamber to support Amendment 229. Thank you.
Thank you. And I call the Cabinet Secretary.
Presiding Officer, Maggie Chapman's Amendment 229, whilst clearly well-intentioned, is unnecessary. Section 85 of the Antisocial Behaviour Scotland Act of 2004 already requires a local authority to have regard to any material that it considers is relevant to the question of whether a person is fit and proper, including any such material mentioned in the additional examples inserted by the amendment. So, picking out particular contraventions of landlord and tenants law risks weakening the generality of the existing provision without adding additional protections. And the Cabinet Secretary for Social Justice did note that point when it was raised at stage 2. In addition to this material already being considered as part of the fit and proper person test for landlord registration, my Amendment 74, which we debated in an earlier group, allows for additional powers to be conferred on the Tribunal to order a landlord to pay a financial penalty or compensation should they fail to comply with the restrictions in a rent control area.
Thank you. Call on Maggie Chapman to wind up. Press or withdraw Amendment 229. Ms Chapman.
Thank you, Presiding Officer. I'll press Amendment 229.
Thank you. The question is that Amendment 229 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is now closed. And the result of the vote on Amendment 229 in the name of Maggie Chapman is yes 23, no 76. There were no abstentions. Therefore, the amendment is not agreed. We now move on to Group 16, Joint Tenancies and Succession of Tenancies. I call Amendment 293 in the name of Katie Clark, grouped with Amendments 232, 233, 234, 235 and 302. Katie Clark to move Amendment 293 and to speak to all amendments in the group. Ms Clark.
Thank you, Presiding Officer. And I speak to Amendment 293 in my name. This bill allows tenants in a joint tenancy to give notice without the consent of the remaining tenants, which is an important improvement to stop tenants being trapped in a tenancy. My amendment 293 gives greater protection for the remaining tenant, as well as the ability to transfer the joint tenancy to someone else. This would hopefully allow more flexibility for people in shared tenancies and the potential for easier transitions between tenancies, and the amendment is supported by campaigns such as Living Rent. The Children and Young People's Commissioner Scotland also support this amendment because they are worried that the bill's provisions allowing one tenant to leave a tenancy does not provide a guarantee that the remaining tenant could continue the tenancy, and so it could leave more single-parent households facing homelessness. Living Rent, Women's Aid and other campaigns are raising this point. This has been a problem in England and Wales and has been reported on by the National Housing Federation, the Domestic Abuse Housing Register and the Domestic Abuse Commissioner. We should not risk going down that path here. Amendment 293 allows at least one party in a joint tenancy to remain in the house. There is not a guarantee on this as the bill is currently drafted, so this amendment will strengthen the law and deal with this situation. The bill also does not prevent the landlord from changing the conditions of a tenancy for remaining tenants, and though this amendment addresses that issue also.
Thank you. I now call Edward Mountain to speak to Amendment 232 and the other amendments in the group. Mr Mountain.
Thank you very much, Presiding Officer. Really, Amendments 233, 234, 235 is really to say that I am proposing that a non-related carer is unable to inherit the tenancy. I think that related carers should have that right. I absolutely agree with that. But I'm not sure that I believe a non-related carer should. 232 is a technical amendment, and I'd be interested to hear what the Cabinet Secretary says in relation to these. I found Katie Clark's Amendment 293, Presiding Officer, an interesting one, and I'll be again interested to see what the Cabinet Secretary makes to this, because I think it's an interesting and good problem for us to be airing. Amendment 302 is I'm not sure. Again, I think 6 months is quite a long time. I think 3 months is where we're at the moment. So I'd be interested to hear your rationale for that, Mr Griffin. I'll leave it at that, Presiding Officer.
Thank you, Mr Mountain. Call Mark Griffin to speak to Amendment 302 and the other amendments in the group. Mr Griffin.
Thank you, Presiding Officer. Just very briefly, Amendment 302 is a technical change, a wording on an amendment to pass at stage 2 on succession. I believe it's a government-supported amendment which amends the period that a qualifying person can remain in a let property following the death of a tenant from 3 to 6 months and aligns with other provisions at this particular section of the bill. Thank you.
Thank you. And I call the Cabinet Secretary.
Presiding Officer, and not too long, but I'm going to take a little bit more time than I have been trying to in the preceding few amendments, groups, on this, because Katie Clark's in particular pertains to an issue that's very, very important to me. So I want to thank her for her engagement on her amendments in this group and more widely her work on supporting those experiencing domestic abuse. This is an issue I feel very strongly about. If I can begin with 293, however, I absolutely understand this stems from concerns about the impact of a joint tenancy being ended for tenants who would like to remain in their property, particularly for victims of domestic abuse who would want to remain in their property. I have considered the need for further change in this area carefully in the run-up to stage 3, and I've looked very closely at Katie Clark's amendments. Unfortunately, looking closely, it is clear that this amendment could mean that a departing joint tenant in the private rented sector could assign their interest in the joint tenancy to the remaining joint tenants, and crucially, without the consent of the landlord. And in those circumstances, the tenancy would need to remain on the same terms. Now, this outcome, i.e. being able to end the tenancy, is already possible under existing provisions in the bill, but crucially with landlord's consent. And if I can just expand that a little bit, this bill introduces a new provision where a victim of domestic abuse, or indeed anybody, could end their joint tenancy without the consent of, in this case, their abuser, as would currently be required. But crucially, this provision already in the bill requires the landlord's consent, which retains legal competence. And in such cases, the departing tenant's interest would be transferred to the incoming tenant, preserving the tenancy. This amendment would remove, as I've said, the landlord's discretion from this process completely and would force them to accept the assignation of the departing tenant's interest to the remaining tenants. Now, in a domestic abuse scenario, we might say, well, that's justifiable, but unfortunately the legal underpinning prevents me from taking that view. Proposals such as those which are in front of us could amount or actually seriously risk being a disproportionate control of the use of the landlord's property for the purposes of Article 1, Protocol 1 of the ECHR. So I can't support the amendment because it is legally flawed, but I do want to take a moment to make clear my determination of supporting the housing needs of women and children facing domestic abuse. And I think it's worth taking time just to point out that some of the other measures we're taking forward to give members comfort, because I know they, like me, will be looking at this amendment wanting to support it, but I have to ask them not to. But on the 2nd of September, the government rolled out across the country the National Fund to Leave. Beyond that, in this bill, in the social rented sector, we will broaden the definition of domestic abuse in housing legislation to align with the 2021 Act. A new legal duty will be placed on all local authority landlords and registered social landlords to prepare and publish a domestic abuse policy. The bill will also require social landlords to take additional steps before initiating eviction proceedings for rent arrears where domestic abuse may have contributed to the arrears. And a government-supported amendment by Megan Gallagher will support tenants affected by domestic abuse to be reflected in the Scottish Social Housing Charter. Beyond that, out with the bill, I'm committing, and I'm letting Parliament know today, that having Part 2 of the Domestic Abuse 2021 Act is an absolute priority for me. This provides a new legal mechanism for social landlords to apply to the court for a tenancy transfer in favour of a victim survivor. That means allowing a woman who's being abused in a social home to stay in her home. And then I can talk about the private rented sector briefly as well. This bill introduces that new process I was talking about, whereby a joint tenant in the private rented sector can end their tenancy, I will in a sec, absolutely, can end their tenancy without the agreement of the other joint tenants, without the agreement of the abuser. That is a massive step forward, and this bill will provide it. Also, in the private rented sector, we've committed to further action to developing a domestic abuse guidance for private landlords and strengthening the existing pre-action protocol guidance for rent arrears. So it's a suite of actions. I'm afraid I can't support Katie Clark's amendment because of the legal flaw, because of the lack of landlord consent, and I'll take Ruth Maguire.
Briefly, Ruth Maguire.
I appreciate the Cabinet Secretary giving way. I welcome what she says about implementing Part 2. Can you give an indication? Can the Cabinet Secretary give an indication of when that might happen? Cabinet Secretary.
It's absolutely, and I understand why she would want to know. It's my intention to have regulations laid by December this year. So, Presiding Officer, I have taken a little bit longer there because I want to give members the absolute assurance that I've given Katie Clark's amendment the most thorough consideration I can, and I regret that I'm unable to support it. Turning very quickly to Amendments 232 to 235, which are, I think, entirely new at Stage 3. These would change the existing rights of carers to succeed to a tenancy after the death of a tenant in both the private and social rented sectors. And it would place an additional requirement for a carer to succeed to a tenancy that they be a member of the tenant's family. I think restricting succession in this way would mean that someone who had given up their principal home to care for someone, had informed the landlord of this and met the qualifying period, would be unable to remain in the tenancy, and that could result in them being made homeless. And I think that's very unfair, so I won't be supporting that. Finally, in relation to Mark Griffin, in 302, I absolutely welcome the constructive discussions with members on this following Stage 2, and have taken consideration of their views and those of Marie Curie and of social housing stakeholders. This amendment will extend the period from 3 to 6 months that a person may remain in a let property in a case where the person is qualified to succeed but has declined it. And I support this amendment, which I think will provide that individual additional time to find alternative accommodation.
Thank you. Just discourage colleagues from having conversations in the chamber while members are on their feet, and I call on Katie Clark to wind up. Press or withdraw Amendment 293. Ms Clark.
Thank you, Presiding Officer. And I will be pushing my amendment to the vote. It is clear that there is a gap in the law in this area, which social landlords in particular are highlighting, and the changes in this bill bring the issue to the fore. I did meet with the Cabinet Secretary and speak with her both before the close of amendments and after it, and I've made very clear that I was very happy to try to work to get agreed working. This is an issue that we need to address. This is an opportunity to address it now. We need a statutory basis for this. We need legislation. I will be raising this issue in further amendments in later groups, and I would urge this chamber to vote for this amendment today.
Thank you. The question is that Amendment 293 be agreed. Are we all agreed? Parliament's not agreed. There will be a division, and members should cast their votes now. And the vote is now closed. Point of order, Edward Mountain.
Thank you, Presiding Officer. My app wouldn't connect. I would have voted no.
Thank you, Mr Mountain. I'll make sure that is recorded. And the result of the vote on Amendment 293 in the name of Katie Clark is yes 25, no 80. There were no abstentions. The amendment is therefore not agreed. I call Amendment 105 in the name of Pam Duncan-Glancy, already debated with Amendment 123. Pam Duncan-Glancy, to move or not move?
Move, Presiding Officer.
Question is that Amendment 105 be agreed to. Are we all agreed? Yes. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. Result of the vote on Amendment 105 in the name of Pam Duncan-Glancy is yes 84, no 21. There were no abstentions. The amendment is therefore agreed. Call Amendment 294 in the name of Mark Griffin. Already debated with Amendment 3. Mark Griffin to move or not move?
Moved.
The question is that Amendment 294 be agreed. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. Point of order, Claire Adamson. Can we have Ms Adamson's microphone?
I'm sorry, Presiding Officer, my app wouldn't have connected and I would have voted no.
Thank you, Ms Adamson. I'll make sure that vote is recorded. Point of order, Edward Mountain.
Thank you, Presiding Officer. I'm afraid again my app wouldn't connect. I would have voted no.
Thank you, Mr Mountain. I'll make sure that is recorded. How are we doing? I think you're too late, but it's on... indeed.
I'm assuming.
I don't think we can reverse that, but it's on the record anyway. Result of the vote on Amendment 294 in the name of Mark Griffin is yes 44, no 60. There were no abstentions. The amendment is therefore not agreed. I call Amendment 295 in the name of Mark Griffin. Already debated with Amendment 3. Mark Griffin to move or not move?
Moved.
The question is that Amendment 295 be agreed to. Are we all agreed? Yes. Are we all agreed? Yes. That is agreed. I call Amendment 296 in the name of Mark Griffin. Already debated with Amendment 3. Mark Griffin to move or not move?
Not moved.
That is not moved. I call Amendment 297 in the name of Mark Griffin. Already debated with Amendment 3. Mark Griffin to move or not move?
Not moved.
That is not moved. Call Amendment 231 in the name of Graham Simpson. Already debated with Amendment 3. Graham Simpson to move or not move?
Not moved.
That is not moved. I call Amendment 230 in the name of Graham Simpson. Already debated with Amendment 3. Graham Simpson to move or not move?
And that's not moved.
Thank you. I now call Amendment 298 in the name of Mark Griffin. Already debated with Amendment 3. Mark Griffin to move or not move?
Not moved.
That is not moved. I call Amendment 299 in the name of Mark Griffin. Already debated with Amendment 3. Mark Griffin to move or not move?
Not moved.
That is not moved. I call Amendment 300 in the name of Ariane Burgess. Already debated with Amendment 3. Move or not move? That is moved. Question is that Amendment 300 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. Votes closed. Point of order, Pam Duncan-Glancy.
Thank you, Presiding Officer. I'm sorry my vote didn't register. I would have voted yes.
Thank you, Ms Duncan-Glancy. We'll make sure that is recorded. And the result of the vote on Amendment 300 in the name of Ariane Burgess is yes 24, no 81. There were no abstentions. The amendment is therefore not agreed. I call Amendment 301 in the name of Ariane Burgess already debated with Amendment 3. Ariane Burgess to move or not move?
Not moved.
That is not moved. I call Amendment 232 in the name of Edward Mountain already debated with Amendment 293. Edward Mountain to move or not?
Moved.
The question is that Amendment 232 be agreed to. Are we all agreed? Yes. Parliament's not agreed. There will be a division and members should cast their votes now. Votes closed. And the result of the vote on Amendment 232 in the name of Edward Mountain is yes 24, no 79. There were no abstentions. The amendment is therefore not agreed. Call Amendment 233 in the name of Edward Mountain, already debated with Amendment
Not moved.
That is not moved. I call Amendment 234 in the name of Edward Mountain.
Not moved.
That is not moved. I call Amendment 235 in the name of Edward Mountain.
Not moved.
That is not moved. I call Amendment 302 in the name of Mark Griffin, already debated with Amendment 293. Mark Griffin to move or not move?
Moved.
The question is that Amendment 302 be agreed to. Are we all agreed? Yes. That is agreed, which takes us to Group 17, Private Rented Sector. Call Amendment 47 in the name of Maggie Chapman. Group with Amendments 303 and 16. Maggie Chapman to move Amendment 47 and speak to all the amendments in the group. Ms Chapman.
Thank you, Presiding Officer. I move Amendment 47 in my name. One of the biggest challenges we face in making this new system of rent controls and other protections for tenants is ensuring that renters know their rights and know how to ensure that those rights are respected. The Generation Rent research on deposits I mentioned earlier this evening before found that the number one reason why renters did not formally challenge deposit decisions they disagree with was that they were not aware that they could. And with the huge change to renters' rights that rent control areas will bring, which will be new to absolutely everyone, it is vital that renters are fully informed. Amendment 47 would require Scottish ministers to create a charter for private sector housing, clearly spelling out the rights and duties of renters and landlords. This is not an unusual or experimental thing. It is much the same as the charter we already have for social housing. The last major housing act, the Housing Scotland Act 2010, placed a duty on ministers to create a charter for those in the social housing sector. Though I would have preferred otherwise, the Charter does not create new rights, but does allow existing ones to be clearly communicated to renters. There is no good reason at all that those living in social housing should have this benefit and those living in privately rented housing do not. I acknowledge the very hard work that Megan Gallagher did on this at stage 2, and I'm grateful for the opportunity of taking this amendment through to this stage. As well as the original amendment from the Conservatives, I've added Amendment 303, which would require the Charter to be reviewed regularly. Amendment 16 ensures that the Charter would need to be provided to tenants and to ensure that rights in relation to rent control are explained to tenants. If colleagues are unwilling to support this, they may wish to ask themselves the following question. Why, yesterday, they were happy to create, with Amendment 155, a duty on landlords to tell renters that they are not supported by rent controls. Why then today do they not think there should be a duty to inform renters when they are? are covered by rent controls. This disparity is entirely inconsistent, and I think it displays a worrying bias towards landlords in the entire construction of the government's arguments we've heard so far this week. So I would urge people to support these amendments. They do just what we already have in the social housing sector. They provide this charter for private rented tenants to make sure that they actually know what their rights are. Thank you.
Thank you. As we are nearing the agreed timeline under Rule 9.8.4ac, I consider it necessary to allow the debate on this group to continue beyond the limit in order to avoid the debate being unnecessarily curtailed. And with that, I call Megan Gallagher.
Thank you very much, Presiding Officer. And as I brought forward this particular amendment, Amendment 47 at Stage 2, I just wanted to give a brief outline as to why the Scottish Conservatives will not be supporting this amendment tonight at Stage 3. And it is because, further to the debate at Stage 2, I've had extensive discussions, particularly with the private rented sector, and they have raised concerns with me, such as any outcomes of the PRS charters, if they were brought into force, would be too slow to address such issues as affordability and lack of supply. And what they have said is that this could easily be addressed in regulations, therefore it would be more amendable should there be more issues that we need to look at in relation to the private rented sector. Yes.
Maggie Chapman.
I thank the member for taking my intervention. Given that this is about, I mean, as you know, it's not about investment, it's not about those broader issues. This is about ensuring that renters know what their rights are. And I struggle with the idea that we can tell renters when they are not covered by a rent control area, but we shouldn't tell them when they are.
Megan Gallagher.
Well, I wasn't saying investment. What I was saying is affordability and the lack of supply, which I'm sure will be two issues that Maggie Chapman would absolutely, or I hope, would agree with when looking at making improvements in relation to good practice. But I do genuinely believe that this could be done without legislation and without it being on the face of the bill. That's maybe where we disagree, and it's where the conclusion that I've now come to in relation to the work that I've undertaken as part of bringing this amendment forward at Stage 2. But again, you know, whether we disagree on this or not, I'm pretty certain that if the amendment doesn't pass, then there will be future discussions in relation to how we can strengthen that good practice to make sure that the private rented sector works, not just for the landlords, but of course for the tenants as well. And I think finding that balance, as we so frequently discuss with this bill, is very important. Thank you.
Thank you. And I call the Cabinet Secretary.
Thanks, Presiding Officer. Amendments 47 and 103, in seeking that PRS charter that we have been hearing about, we would have to do this within 12 months and introduce 5 yearly review requirements. The Scottish Government, just to say in respect to this question about information, we regularly run campaigns that are designed to ensure that both landlords and tenants are aware of their rights and their obligations within the PRS, and we frequently direct landlords and tenants to appropriate guidance. Now, as we said at Stage 2, we don't think that legislation and placing a statutory duty on ministers to ensure the delivery of a PRS charter is appropriate. Instead, consideration of the need for one and that need to communicate rights and responsibilities can come in a private rented sector strategy. Now, work is underway within the Government's Housing to 2040 board and our expert panel who make up the board on exactly that, on a PRS strategy, and the consideration of the need for a charter is part of that. I believe that work is best undertaken in that board space, and so for these reasons I can't support those amendments. Amendment 16 seeks to introduce a similar amendment as at Stage 2, requiring a landlord to provide additional information to the prospective tenant. Again, I agree. It is vital that tenants are aware of their rights, empowered to use them, and of course this includes having access to relevant information that may affect their tenancy. However, some of what this amendment would require would mean that landlords were providing information that actually is much more readily available from other sources. And looking at the breadth of issues that they might be required to provide, there's a risk that some of this could amount to legal advice, which would be clearly a conflict of interest and inappropriate. So there are existing statutory requirements that require specified information to be provided by the landlord free of charge to the tenants at the point their tenancy commences. This is important, but that amendment, I'm afraid, goes too far.
Thank you. I call on Maggie Chapman to wind up. Press to withdraw Amendment 47. Ms Chapman.
Thank you, Presiding Officer. I will press Amendment 47.
The question is that Amendment 47 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division in members that should cast their votes now. And the vote is now closed. The result of the vote on Amendment 47 in the name of Maggie Chapman is yes 23, no 77. There were no abstentions. The amendment is therefore not agreed. I call Amendment 303 in the name of Maggie Chapman, already debated with Amendment 47. Maggie Chapman, to move or not move?
Not moved.
That is not moved. I call Amendment 16 in the name of Maggie Chapman, already debated with Amendment 47. Maggie Chapman, to move or not move?
Not moved.
That is not moved. I call Amendment 304 in the name of Paul Sweeney, already debated with Amendment 101. Paul Sweeney, to move or not move? Move. Question is that Amendment 304 be agreed to. Are we all agreed? Yes. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote's now closed. Point of order, Edward Mountain.
Thank you, Presiding Officer. I still continue to have problems with my app. I would have voted no.
Thank you, Mr Mountain. I'll make sure that vote is recorded. The result of the vote on Amendment 304 in the name of Paul Sweeney is yes 23, no 79. There were no abstentions. The amendment is therefore not agreed. I call Amendment 305 in the name of Mark Griffin, already debated with Amendment 101. Mark Griffin, to move or not move? Moved. The question is that Amendment 305 be agreed to. Are we all agreed? Yes. We are not agreed. There will be a division. Members should cast their votes now. And the vote is now closed. And the result of the vote on Amendment 305 in the name of Mark Griffin is yes 44, no 57. There were no abstentions. The amendment is therefore not agreed, which takes us to Group 18, Homeless Persons and Persons Threatened with Homelessness. Call Amendment 306 in the name of Sarah Boyack, grouped with amendments as shown in the grouping. Sarah Boyack to move Amendment 306 and speak to the other amendments in the group. Ms Boyack.
Thank you, Presiding Officer. I first of all want to draw members' attention to my register of interests and my previous work with the Scottish Federation of Housing Associations. I think this section of the bill is absolutely critical because it's about tackling homelessness and, crucially, it's about preventing homelessness, which is not in current priority. It's not working at the moment because you've got thousands of families and people becoming homeless and getting stuck in temporary accommodation for too long. It's a huge cost to them as individuals, but it's also a huge cost to our local authorities. So there's something about making sure that we prioritise the prevention of homelessness, and that is the purpose of my amendments this evening. Firstly, Presiding Officer, I'd like to move Amendment 306 in my name, because this amendment will establish a national register of homeless households. We can't plan for what we don't measure, and right now data is fragmented across our councils. If we were to have more effective planning, and if we had a register, it would help understand the scale of the national housing emergency, because we currently don't have detailed enough data on those threatened with homelessness or those who are currently experiencing it. Now, we had a long debate about this several months ago now with the previous housing minister, and we did discuss the issue of data protection, but I think the amendment I've got in front of the Parliament tonight addresses both data protection and cost concerns, because the detail sits in affirmative regulations after consultation would be carried out by the Scottish Government. It would be a minimal data set, it would be role-based access and audit. The Parliament would set the framework through this legislation, and ministers would be able to bring back the detailed safeguards for scrutiny and also to design the detail of it, learning on the experience from discussions that I know will have been heard over the last few months with our new Cabinet Secretary for Housing. If we were to accept this amendment, we'd ensure that organisations are able to work together to allocate suitable housing, which would streamline the resources required for a household which is applied to be homeless in multiple local authority areas. It also gives more detailed information about the depth and breadth of the housing issues that are facing Scotland. And it's absolutely critical to understand the scale of the issue in order to identify how many new homes are needed and exactly where. And this amendment gives us the opportunity to get the exact information on the scale of the housing need through a deliberative, preventative framework. And that has to be seen as an opportunity. And having a high degree of accuracy in the number of homeless households, where they are, will help us prioritise where we need to focus on building and planning for the exact types of homes that are needed urgently to address homelessness. Amendment 313 would create a clear statutory gateway for proportionate information sharing when a relevant body believes someone is homeless or threatened with homelessness, and prevention fails when our health systems, our justice systems and our education systems know there's a risk, but people don't ask for the help they need and then they just slip through the net. So this provision in this amendment would give clear, early legal sharing and with an opt-out, so people don't have to tell their story again and again before they get help. At our cross-party group on housing, we actually published a report on student homelessness, and it was incredibly moving to speak to students because of the huge pressures they're facing. You think about how that impacts on their lives going forward, or young people that are stuck in temporary accommodation. This would give us the opportunity to actually give a legal basis for action. Now, I know ministers might say that guidance can deliver this, but I think we've got a bill in front of us which would give a legal basis and would enable us to come into the detail that ministers could consult on in detail with the Information Commissioner Officer and stakeholders, and then come back to Parliament. We need to share only what's necessary, no more, and only to stop a crisis before it happens. So that's what Amendment 316 aims at. For the next set of amendments, Presiding Officer, there's a raft of organisations I've included in my amendments, because the Ask and Act duty must exist where actually people are aware of those risks and then do something about it, because that's not happening at the moment. Naming bodies would avoid buck passing and give consistency. The duty is proportionate to ask, signpost and make a referral as appropriate. Absolutely not about taking over the roles of our councils, but helping them. So, I've got a series of amendments, 7, that actually name key organisations. Colleges of Further Education, British Waterways Board, Crofting Commission. 3 bodies that potentially see risk early. Colleges support students facing family or financial shocks. British Waterways Board and the Crofting Commission have an access to see rural households whose housing security can be fragile. So a simple duty to ask and act would help prevent crisis before those reach the Council. Amendment 319, community planning partnerships within the Community Empowerment Scotland Act would enable coordinated place-based prevention, and CPPs are potentially the natural form to spot systemic risks. For example, local employment changes, transport disruption, service design would close the loop, so we have practical referrals, not plans. And I know Elena Whittam's also got an amendment aiming to add community planning partnerships. So hopefully there's a degree of support across the chamber for this key issue. As briefly as possible, Ms Boyd. My last 4 amendments: Highlands and Islands Enterprise, National Park Authorities, regional transport partnerships, a range of different organisations that are public sector organisations. Particularly want to highlight Social Security Scotland. These are important because these could prevent people becoming homeless, save the public sector a huge amount of money at local authority level, but actually keep people well and safe and stop them becoming homeless. Thank you, Presiding Officer.
Thank you, Ms Boyd. I now call Jeremy Balfour to speak to Amendment 106 and other amendments in the group. Mr Balfour.
Thank you, Presiding Officer. And can I agree with the opening remark that Sarah Boyack has just made? But I do believe that this section of the bill is vitally important for the whole of Scotland, but in many ways particularly for those of us that represent Edinburgh and Lothian, which is facing a major issue around homelessness and the lack of housing. Can I also thank the many third sector charities that have engaged with both myself and with the committee generally in regard to bringing things forward. Can I not add too much to Amendment 109 in regard to Social Security Scotland? I agree with the comments that Sarah Boyack made earlier. I do think perhaps that she has gone slightly too far in some of the organisations, but undoubtedly Social Security Scotland is one that should be there. If I can go to Amendment 119, and the reason I bring this forward again is that in many ways we are being asked in regard to this bill to take a leap in the dark. We're being asked that things will be followed on in regard to regulations once these pilot programmes have been worked their way through. Now, these programmes haven't started yet. We have very little detail in regard to actually how they will work in practice and what information they will give. And it would seem to me irresponsible for this Parliament in regard to making decisions for the next Parliament unless this pilot project can be fully debated and both the lessons learned, both positively and negatively, can be worked out. And that's why I think it is important that the next Scottish Government, whatever colour they are made up of, bring forward a report that the whole Parliament, and in particular committees, can scrutinise in detail. In regard to Amendment 107, this again is a similar amendment to that of Sarah Boyack in regard to data sharing. I know all of us MSPs can get frustrated by the number of forms we have to get our constituents to fill in before we can get information from a local authority or from a health board. And across the piece, we are seeing often the excuse made by NHS or by local councils or by other public bodies, we can't tell you this because of data protection. This will not work unless organisations are willing to share appropriate information with each other. If we're going to encourage people to come forward and share information again and again, they do not want to do that. If they do it once, they don't want to have to do it again. And my fear that unless we can get this worked out properly, then we will find that the data sharing is an excuse used by those that are not wanting to take part in this scheme. 1008 is a probing amendment. I don't intend to move that, but I am concerned that this bill has lots of carrots but not many sticks in it. The presumption of the Cabinet Secretary and of the government is that everybody will play nicely and do what they're meant to do. My experience, and perhaps I'm just old and cynical, is that that is not the reality, and I do worry that there's not enough sticks to encourage those who aren't playing as the Cabinet Secretary would want them to. And then finally, Presiding Officer, in regard to Amendment 106, in regard to the suitability of accommodation. Again, I brought this at stage 2, and I also had a helpful discussion with the Cabinet Secretary on this over the summer. I think, and I don't want to prejudge what she's going to say, but I think she will say that this is another thing that is already in legislation and is not required. Can I point out to her gently that I have numerous occasions been contacted, particularly by disabled constituents, but also by those who have maybe many people in their family, and they have been offered accommodation which clearly is not suitable. Local authorities are not doing this in a way that is fair to families. Too often disabled people are put in accommodation that is clearly not suitable for that. And I think to have this amendment in would strengthen the law as we have at the moment and make sure that local authorities put families and individuals in accommodation that meets their needs rather than just dumping them wherever they can find them. With that, I will conclude. Thank you, Presiding Officer.
Thank you, Mr Balfour. I now call Pam Duncan-Glancy to speak to Amendment 307 and other amendments in the group. Ms Duncan-Glancy.
Thank you, Deputy Presiding Officer. And I brought these amendments at stage 2 with the support of many care leavers and also support from the Children's Commissioner, because specifically this issue is something that is of great concern to a number of people who are in the care system and leaving the care system, who feel they get failed at the point at which they're leaving it and they don't get the support they need to access housing. Amendment 307 would put a duty on local authorities in cases where the homeless applicant is a care leaver to offer them a referral to organisations that provide through care and aftercare support services. It would apply to care leavers, and it's defined there as those who are under the age of 26 and still entitled to through care and aftercare services from the local social work department. When I brought forward the amendment in stage 2, I noted that despite the fact that care leavers are entitled to those services, what we see in practice is that where someone who has care experience is made homeless or is threatened with homelessness, there's a disconnect between housing providers and other areas of state support. The Children and Young People's Commissioner Scotland noted that some care leavers are unaware that support exists and that there are examples of them not receiving that entitlement when a situation of potential homelessness arises. Claire Burns from Celsius told the Education, Children and Young People Committee last week that we had to look at aftercare, and I quote, because there was too much feedback about it not working. Fraser McKinlay of the Promise told committee that only 48% of people access aftercare and support they need. So for these reasons, having opportunities to refer on to other organisations is not just helpful, but could address some gaps in the statutory services and provide the additional support needed. The Cabinet Secretary at Stage 2 said that the homelessness system in Scotland is based on whether someone is homeless or threatened with homelessness, not on their circumstances. She also noted that legislation recognises the specific needs of particular groups through regulations and guidance. However, from the evidence set out, it is clear that care experienced young people are still falling through the gaps, and I think this amendment could help to address that. Amendment 308 in my name, Presiding Officer, seeks to place a duty on Scottish ministers to prepare guidance for local authorities on through care and aftercare support that could be offered to care experienced young people. It specifies that in preparing the guidance, ministers and the government should consult local authorities and organisations that provide support to care experienced young people, as well as others whom the ministers think appropriate, and those views must of course be represented. Amendment 308 follows Amendment 307 by seeking to ensure consistency across the support that is provided. Such inconsistency is well recognised by stakeholders, and both of these amendments are supported by Who Cares Scotland and the Children and Young People's Commissioner Scotland, whom I'd like to thank for engaging with me on these issues. Thank you, Presiding Officer.
Thank you, Ms Duncan Glancy. I now call on Eleanor Whittam to speak to Amendment 314 and other amendments in the group. Ms Whittam.
Thank you, Deputy Presiding Officer. My amendments 314 and 315 seek to place responsibilities on community planning partnerships to have regard to the need to prevent homelessness and to any relevant guidance issued by Scottish ministers. This was a recommendation from the Prevention Review Group, of which I was a member, as there was a realisation of the important strategic roles CPPs play in their locality across all sectors. This is intended to support the bill's intention that prevention of homelessness becomes a shared public responsibility, and does this by requiring the key local strategic planning body to consider this as part of their functions. This would be on top of the requirements of relevant bodies, many of whom may be community planning partners, to ask individual service users about their housing situation and act in line with their own functions. Through its consultation, the Homelessness Prevention Review Group identified the strategic importance of CPPs in homelessness prevention, including in consultations with COSLA, ALACHO and Solace. It builds on responsibilities under the Fair Scotland Public Sector Equality Duty to reduce inequalities of outcome as a result of socio-economic disadvantage, and helps to join up homelessness prevention with related strategic local priorities such as tackling child poverty, community justice, improving mental health, employment opportunities and addressing violence against women and girls. Sarah Boyack's Amendment 319 seeks to achieve a similar purpose by including community planning partnerships as a relevant body. The difference with my amendment and Sarah Boyack's amendment is that these do not subject CPPs to the operational duties in sections 36A to C, which are not relevant to their strategic planning functions. Now, I understand that CPPs are not considered to be legal entities, but they are indeed the linchpin of local strategy setting. And I would hope that the Cabinet Secretary could perhaps say something about how they can be involved in any guidance that's issued to make sure that they have due regard to their role in prevention.
Thank you, Ms Whittam. And I call Megan Gallagher to speak to Amendment 316 and other amendments in the group. Ms Gallagher.
Thank you, Presiding Officer. I brought Amendments 316 and 317 to the Stage 2 committee debate and have continued to liaise with the Chartered Institute for Housing to bring this amendment back at Stage 3. I think we need to recognise the resourcing and capacity pressures on local authorities from the prevention duty, and this amendment intends to set out a training continuous professional development, a CPD requirement for key housing management homelessness practitioners, so they can help ensure that practitioners remain skilled and knowledgeable. Letting agents, for example, in Scotland have to complete a minimum of 20 hours CPD every 3 years alongside having a core qualification. Recognising the potential impact of new duties on the housing workforce, I think the government should help develop a housing skills and employability task force that would ensure that there are sufficient routes into the sector to address the issues facing social landlords over the next few years. On the Ask and Act duty, I think it would be important to have that continuous professional development in place there as well, just given the nature of Ask and Act and all of these additional requirements that will be placed on local authorities in order to fulfil their duties. There, just a couple of brief comments, Presiding Officer, on other amendments in this grouping. We will be supporting the amendments in the name of Jeremy Balfour. I do believe that these are sensible amendments, as with Pam Duncan-Glancy in relation to care leavers. I know that Pam Duncan-Glancy, alongside my colleague Ros McCall, does a lot of work in this area, and I thank her for bringing these amendments and look forward to voting in favour of them at the relevant time. Sarah Boyack, we will also be supporting some of your amendments. I think there might be too many in there, but I suppose you've got to be in it to win it with stage 3 amendments. So again, we will be voting for ones that we think are relevant to the face of the bill, and I will leave my comments there, Presiding Officer. Thank you.
Thank you, Ms Gallagher. I now call Mark Griffin to speak to Amendment 322 and other amendments in the group. Mr Griffin.
Thank you, Presiding Officer. I've got 3 amendments in this group in kind of 2 distinct categories, but I also want to express my support for all other amendments in this group and highlight the importance contributions of this grouping to refine and expand the part of the Act which brings the duty of Asking Act onto the face of primary legislation. Turning to my own Amendment 322, this proposal would ensure that GPs, providers of primary medical services, are included in the Asking Act duties set out in Part 5 of the bill. Now, many organisations have highlighted that GPs are a crucial point of contact for people at risk of homelessness, and I think their omission from the list of relevant bodies is a real gap that needs to be addressed. We know the evidence is overwhelming that there are strong links between health and housing, and that people's use of health services often peaks just before they make that first homeless application. So having GPs covered in the Act duty, I think, is absolutely essential. Setting out a clear list of bodies with duties placed upon them is important for clarity and accountability, and without that there is a lack of clarity regarding the expectations for those not explicitly listed. Now, I absolutely recognise the concerns about GP capacity and the fact that they are essentially private business, but I think given the close links between a person's use and interactions with health services and the point where they make their first homeless application, I think this is a crucial area that is missing from the bill, and it's something that should be urgently addressed. On Amendments 331 and 383, these are to address a technical but what I think is a crucial gap in application of UNCRC to Part 5 of this housing bill relating to homelessness prevention. Now, this amendment has been developed with the support of the Children and Young People's Commissioner for Scotland, who have been clear about the need for change in this area. The Part 5 of the bill introduces important new duties to prevent homelessness by amending Part 2 of the Housing Scotland Act 1987. But crucially, Presiding Officer, because the 1987 Act is an Act of the UK Parliament, these new provisions fall outside the scope of the UNCRC Incorporation Scotland Act 2024. So what that means as it stands is that public authorities would not be legally required to act in accordance with the UNCRC when carrying out these duties, and crucially children would have no power to challenge a failure to uphold their rights. Now, this is different from other parts of the bill and could leave some of the most vulnerable children without enforceable rights. Amendment 331 provides a solution by allowing the Scottish Government to repeal and restate Part 2 of the 1987 Act, including the new homelessness prevention duties, so that they then fall within the scope of the UNCRC Act. This is not about duplicating law, but ensuring that children's rights are fully protected and enforceable. Now, I understand the Government isn't opposed to this in principle, and I welcome that, but I do urge members to consider the omission caused by that anomaly of relying on a 1987 Act of the UK Parliament, that it would be right to ensure that children's rights are upheld and covered by passing these amendments. Thank you.
Thank you, Mr Griffin. And now calling the Cabinet Secretary to speak to Amendment 326 and other amendments in the group. Cabinet Secretary.
Thank you, Presiding Officer. And similarly with one or two groups this evening, it is a large one. And again, I do want to give members the courtesy of the Government's response to their amendments, but I will try and do it as swiftly as I can. Beginning with Amendment 306 in Sarah Boyack's name, this requirement for ministers to establish and maintain a register of homeless households. I understand her intention. I listened very closely to what she was saying, but the point is that local authorities already keep a record. They already have a record of anyone who makes an application for accommodation or for assistance in obtaining housing under the Housing Scotland Act 1987, and a record of all those assessed as homeless or threatened with homeless. Local authorities will continue with these records until they have discharged their obligations in respect of those individuals. We also already have annual homelessness statistics, the most recent of which were just published last week. So this is duplication, and it's not necessary, and I can't support it. Amendment 1... I will briefly, yes.
Sarah Boyack.
I appreciate the Cabinet Secretary taking intervention. The issue is about the joined-up information sharing between local authorities. That's the key issue I'm trying to get at here, because there are records in every local authority, but we're not seeing them joined up so people can be registered in several local authorities, and that surely doesn't make sense.
Secretary.
Well, there are existing means of accessing that information. I'm not sure if she's suggesting that it would be a public register, because I think we would both agree that that would be an inappropriate use of data. But it is the fact that they already exist and that we already have national statistics, which means I'll resist this amendment today. Amendment 106 that Jeremy Balfour lodged and spoke to. Again, this is about securing permanent accommodation and having regard to the particular needs of the person arising from their protected characteristics. And Mr Balfour is quite right in preempting what I'm going to say, which is that this is already provided for in law. And the fact is that if it's not working, in his view, then we need to work to make sure that the law as it stands is being implemented, not to layer more legislation atop it and confuse the landscape. Amendments 307 and 308 in Ms Duncan Glancy's name in respect of care leavers. Much of this is already catered for in the bill, and I've looked very closely to make sure that's the case, because with ministers' power to prescribe the types of advice and assistance that must be provided to those who are threatened with homelessness, we have the opportunity to set that out in a way that's very specific to young people leaving care. This will be informed by our consultation following the Care Inspectorate's thematic review and the potential package of support for young people leaving care that the Scottish Government is working on with partners. And I'd just like to assure Ms Duncan Glancy in respect of care leavers, Mr Balfour in respect of people requiring their protected characteristics to be heard and understood. I want to assure them that I will be making sure that those powers under the bill to understand and then make provision for support are used to support these individual groups. Yes, I will do.
Duncan Glancy.
I thank the Cabinet Secretary for taking the intervention on the point. And I actually don't doubt her intentions, but can she set out to Parliament what will be different about the guidance under this bill for care experienced young people, as opposed to the guidance under all the other legislation that is there to support care experienced young people, but yet there is still a gap in this particular type of support?
Cabinet Secretary.
Well, I suppose the big, if I understand her question correctly, the difference with here is it will pertain to their housing needs, and it will be informed by that work that the Government's doing and following the Care Inspectorate's thematic review, which is expert work that I will be seeking to make sure is replicated under this piece of work. Amendments 107 and 108 in the name of Jeremy Balfour. These relate to the new Ask and Act duties of relevant bodies. 107 would confer a new power for a relevant body to share information with any other relevant body for the purpose of preventing or relieving homelessness. This allows relevant bodies to share information for the purposes of the exercise of their new functions. But these functions include acting to remove or minimise the threat of homelessness. The purpose of relieving homelessness is solely the function of a local authority. So information sharing powers in the bill are important. The ones that are there are already sufficient to enable bodies to perform their duties under Ask and Act. What Amendment 107 seeks goes beyond what we would be asking bodies to take on under Ask and Act. Amendment 108 would confer a regulation-making power on Scottish ministers to specify the procedure by which a person who's been supported under the new section may raise a concern. But again, I just need to point out the bill already amends Section 35A of the 1987 Act to make it clear that a person may request a review of any decision by a local authority, and this was something that Mr Balfour and I were able to discuss in advance of stage 3. 313 in Ms Boyack's name provides information sharing power to be set out in regulations, but as I mentioned, the bill inserts a new section 36CA into the 1987 Act, allowing relevant bodies to share information. I agree it's very important, it's provided for. Amendments 314 and 315 from Elena Whittam in respect of community planning partnerships. This section places a duty they are relevant to Section 36D of the Bill, which places a duty on relevant bodies in the exercise of their functions to have regard to the need to prevent homelessness. I want to thank Elena Whittam for taking the time to highlight the importance of CPPs, and likewise to Sarah Boyack, who did likewise. The key point here is that community planning partnerships, they absolutely play an important role in coordinating services to reduce inequalities, including in preventing homelessness, but community planning partnerships do not deliver services themselves. They coordinate them. Now, we have the powers to update the list of relevant bodies by regulation at an appropriate time, importantly following consultation with bodies in question, and for that reason I'd ask that these ones not be pressed today, but I'll continue to work with members on CPP's roles. Amendments 316 place a duty on ministers to set out principles that would apply to the Ask and Act duties, but there are already clear objectives in the bill in respect of Ask and Act, and at stage 2 a new section 36C was amended, giving ministers the power to specify additional actions under regulations. I note that some of the principles listed in the amendment include duties that are already placed on relevant bodies, such as the need for them to work together. If required, a statement of principles could be set out in guidance, and I think that principles are clearly more suited to guidance than is proposed. Amendment 317 in respect of continuing professional development. Again, I think that it is a positive thing to require continuing professional development to ensure bodies with Ask and Act duties are continuing to be informed in an appropriate way. But local authorities are already required by law to provide good quality housing and homelessness advice free of charge to people in their area, and we will be able to provide for the relevant kind of continuing professional development for other bodies in regulation. Amendment 317, Megan Gallagher's amendment, would also require ministers to make regulations subject to affirmative procedure, and therefore I'm afraid there are technical difficulties with that amendment as well. Trying to move as fast as I can through these, Presiding Officer. In principle, we're just going to move to the section now where a number of bodies have been proposed to be added to Ask and Act. And I just want to say from the offset that in principle the Scottish Government is willing to consider adding any appropriate body to the list of relevant bodies where there's evidence that this will help to achieve what we all want to achieve, which is preventing homelessness. But crucially, where this is identified, it should only be done following consultation and discussions with that body. Section 41 of the bill confers a new power on ministers to modify the meaning of this and add bodies to the list. And I should note to members that those who are currently listed, they've previously been consulted, and the list as it stands was based on recommendations of an expert group, which included people with lived experience of homelessness. So I'll quickly try and move through some of the suggested bodies, but the principle is that we would add them if appropriate, having consulted. Amendment 322 speaks to GP practices. I know these are of particular interest. We have included health boards and special health boards in the list already, because I think community link workers in particular could have a really important role to play. And I am happy to consider further bodies, but I don't think GPs are appropriate at this stage. Similarly, with 324, we are engaging with the Scottish Fire and Rescue Service about their potential inclusion at a later date, but that work has not completed. On Amendment 325, the bill already includes the Scottish Ministers on the list of relevant bodies insofar as we have functions in relation to social security, and that also attends to Amendment 109. Moving to 110 and 236 in Maggie Chapman's name, these relate to a different topic, to intentional homelessness. 110 would require ministers to carry out a public consultation within a year of royal assent on removing the ability to treat intentional homelessness differently, followed by a report and other provision. However, the amendment provides no timescale for the report and allows ministers to repeal and replace existing primary legislation by regulations with no specified parliamentary procedure. This would be constitutionally inappropriate and I can't support it. Amendment 236 would require a report within 2 years. This, of course, risks preempting the outcome of the consultation that is planned later this year. A more appropriate approach is that which I have sought to set out in Amendment 326 in my name. It provides a delegated power to modify, repeal or replace the legislative framework on intentional homelessness with a requirement to consult on the use of affirmative procedure. So this will allow for proper engagement and detailed policy and legal analysis while ensuring full parliamentary scrutiny. I think it's important that we don't preempt the findings of that important work on intentionality, and therefore I'd ask that the other amendments are not supported. Amendment 18 and similarly 332 from Maggie Chapman are seeking to legislate for homelessness prevention strategies in respect of the LGBT+ community and the Gypsy Traveller community respectively. Again, I absolutely acknowledge that some groups, including those listed, will have specific challenges that put them at risk of homelessness. However, the homelessness prevention measures in this bill, like in Scotland generally, apply to all of those threatened with homelessness and do not discriminate on particular groups. Nearly there, Presiding Officer. Amendments 330 and 382 from Edward Mountain seek to clarify homelessness rights for those in accommodation tied to their employment. Local authorities are already required by law to assess someone's needs based on their circumstances and their current accommodation, regardless of their employment status. So I will oppose this amendment as unnecessary. Amendments 331 and 383 in Mark Griffin's name, referring, as he's taken us through, to the UNCRC. I hope Mr Griffin is aware of my commitment to meeting the needs of children experiencing homelessness, but this amendment isn't the right way to do it, I'm afraid. The power that proposed to be conferred by 331 is far too broad. It would allow Scottish ministers to repeal and reenact Part 2, the whole of Part 2 of the 1987 Act for any purpose, which is not appropriate in secondary legislation, and I can't support it. If I have time, Presiding Officer, yes.
Martin Whitfield.
I'm very grateful to the Cabinet Secretary taking the intervention, but isn't it right that this is the very method that the Scottish Government have indicated on a number of occasions that they are going to use to ensure that the UNCRC is available for young people? And at this offering on a bill that predated the start of the UNCRC, they haven't taken the opportunity to actually bring it into account, which is what they assured this chamber that they would do.
Cabinet Secretary, and if you could begin to draw your remarks to conclusion.
Absolutely will. I can't comment on other bills, although I'm sure my ministerial colleagues who deal with the UNCRC in particular would know the details of that. What I know in this provision is that I'm not prepared for massive swathes of homelessness law to be able to be enacted and repealed by secondary legislation. I think that's inappropriate. Presiding Officer, if you need me to wind up, I probably will have to miss some of the other amendments, but if you need me to, I can.
I would be grateful, certainly, Cabinet Secretary, if you could begin to draw your remarks to a conclusion.
Okay, I will do so very quickly. Amendments 335 and 385 from Maggie Chapman refer to the right to keep pets. We've already addressed pets and personalisation in the bill, and although there is no legal duty to do this, local authorities will be expected to consider the housing needs of any individual, including their pets. Similarly, 333 and 384. In respect of Housing First, I hope Maggie Chapman knows Housing First is a approach which has the greatest respect and support from me. I've just committed an extra £4 million to expand it this year. I can't support 384, but I will support 334, which calls for an annual report to be published on Housing First. And I'll leave it there, Presiding Officer.
Thank you, Cabinet Secretary. I call Maggie Chapman to speak to Amendment 110 and other amendments in the group.
Thank you, Presiding Officer. I've got several different amendments in this group, and as I've been brief in previous groups and accepted interventions, I ask for a little bit of patience here. Amendments 110 and 236 concern the power to assess someone as intentionally homeless. Although some actions might seem intentional, they often stem from trauma, violence and disadvantage. And if looked at from this point of view, they are absolutely not about choosing to become homeless. Rather, such action should be taken to escape abuse, to get away from dangerous or compromising situations, or to keep people safe. Crisis Skylight in the Lothians has not worked with anyone assessed as intentionally homeless who has not also had underlying support needs. Too many homelessness support services use up resources challenging intentionality decisions. Crisis has made it clear that the intentionality test cannot be reformed to make it fairer. Instead, they say it must be abolished and replaced with a much tighter concept. If someone turned up to a hospital with an injury, our NHS would not provide lesser or no treatment simply because the person had deliberately injured themselves. We would treat their injury and treat the person with compassion and dignity. That is how our health service works. It is how our homelessness services should work too. We have been moving in that direction for a long time, and we already have removed the requirement for local authorities to assess intentionality. Let's finish that job and abolish this cruel assessment, not just tweak around the edges. If the Scottish Government is not able to support doing this in 110, I ask at least for it to keep the issue on the agenda by supporting the reporting requirement in Amendment 236. I do acknowledge the Scottish Government has listened to what Greens and others have said at previous stages. Having not been active on this issue at stage 2, the Cabinet Secretary's Amendment 326 allows us to change the definition of intentionality, which is welcome. However, it does stop short of complete abolition and replacement with a more appropriate alternative, as Crisis and others have suggested is necessary. Amendments 18 and 332 require homelessness strategies for LGBTQ+ and Gypsy Roma traveller communities. These communities have particular challenges stemming from stigma and discrimination, and that stigma and discrimination is on the rise. I'm very grateful to LGBT Youth Scotland for their help in preparing this amendment, and for Alexander Stewart's work on the amendment for the Gypsy Roma traveller communities. If we are serious about our homelessness prevention work reaching those most in need, we need targeted and specific support for communities who bear the brunt of stigma and discrimination. Amendment 335 empowers the Scottish Government to extend the right to keep a pet to those living in homeless accommodation. The bill already does that for social and private sector housing tenants. I would hope that everyone in the Chamber would want to extend this benefit to those without a secure home. Amendments 333 and 334 aim to support the rollout of Housing First. Housing First is a silver bullet in many ways for tackling homelessness for those with multiple and complex needs. But it is rolling out too slowly. The Housing First experts I've been in discussion with in writing these amendments are concerned that the energy and speed behind Housing First has ebbed somewhat. 333's right to Housing First would act as a major incentive to up the tempo in rolling out Housing First support, and 334's reporting mechanism would provide a clear steer for doing so. I understand from an email from a Scottish Government representative that the Scottish Government will support 334, and I'm grateful for that. But I do think we need a more complete picture for Housing First, and I would urge the Government and others to support 333 as well. And then I'll leave my comments there. Thank you.
Thank you, Ms Chapman. I call Edward Mountain to speak to Amendment 330 and other amendments in the group.
Thank you very much, Presiding Officer, and I rise to speak to Amendment 330. I fundamentally disagree with the Cabinet Secretary, and I find it quite frustrating when my amendment is written off as unnecessary. It is necessary, in my opinion, for the simple reason that those people who live in accommodation that's provided as part of their jobs will, should they no longer have that job, no longer have the accommodation. So the point is that there's a balance here, as there is with all things in life, is that the person coming in to take on their job will probably need that house, and to stop that person moving in means that it's unlikely the business will be able to function as is. Now, I take the point that the Cabinet Secretary makes, that local authorities have a duty to assess the condition of each person who applies for housing, but that is to assess. This amendment is a different amendment. It says that a person will be classed as homeless and that they will be rehoused within 3 months of their employment ending. I think that's a fair balance, and I think it's right. Amendment 382 is consequential to Amendment 330, and I'd just say at this stage I do think it's necessary, otherwise I wouldn't have brought it. I've looked at the other amendments in the group. I will be able to support Jeremy Balfour's, and there's much of Sarah Boyack's amendments that I like. I think she maybe pushes a bit far on occasion and stretches the envelope, but I know that she feels she's doing the best and therefore that they're necessary as well. But I'll be voting for them where I think they're appropriate. Thank you, Presiding Officer.
Thank you, Mr Mountain. And I call on Sarah Boyack to wind up and press or withdraw Amendment 306.
Thank you, Presiding Officer. I actually think this has been a very useful and a constructive debate about the variety of amendments, because what we are all trying to do here is to actually strengthen this housing bill and to actually strengthen the work that's done right across the public sector and by a range of organisations to prevent homelessness, because the issue isn't going away. I will push my amendment, Presiding Officer. I think this is a now issue, and there's a lot being done by local authorities and charities, but we need to actually do more. So strengthening the framework is absolutely critical in terms of ask and ask duties, and making sure that we link prevention right across the country so that people actually see that difference being made. And I think if we are to see this bill being successful, the amendments that others have proposed, Jeremy Balfour's comments about the housing emergency were absolutely bang on. The need for permanent accommodation for people who are homeless, protected characteristics, the issues that were mentioned by Elena Whittam about child poverty, the employment issues that were raised by Elena Whittam and also Edward Mountain, and then that issue that Megan Gallagher raised about shared responsibilities. I think there's such a lot in here where we actually want the Cabinet Secretary to say, we've not done this, tick the box, the bill gets passed. It is about what happens next. So I suspect some of us would be very up for future conversations, because this is about supercharging action against homelessness. And I think some of the comments made by Pam Duncan-Glancy about care leavers, absolutely critical. Mark Griffin's comments about GPs and children's rights, they are central to this in terms of protecting current people but also future generations for our society in Scotland, and also disadvantaged groups that Maggie Chapman mentioned. So I think there's an awful lot in here. I hope the Cabinet Secretary will be prepared to discuss these issues with us. I hope when I come to push my amendments I go with the right ones. Difficult to read the room exactly which ones people will support. But I think I go back to that point, Cabinet Secretary. There are some things that you've talked about that the government will do more of. It would be very good for us to be able to influence future consultation, the guidance, because making sure guidance is actually implemented is absolutely critical if we're going to prevent homelessness, because it couldn't be a more urgent issue. Thank you, Presiding Officer.
Thank you, Ms Boyack. And the question is that Amendment 306 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 306 in the name of Sarah Boyack is yes 46, no 60. There were no abstentions. The amendment is therefore not agreed. I call amendment 106 in the name of Jeremy Balfour, already debated with amendment 306. Jeremy Balfour, to move or not move?
Move.
Thank you. The question is that amendment 106 be agreed to. Are we all agreed? Can I just confirm we're all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 106 in the name of Jeremy Balfour is yes 47, no 59. There were no abstentions. The amendment is therefore not agreed. I call amendment 307 in the name of Pam Duncan-Glancy, already debated with amendment 306. Pam Duncan-Glancy, to move or not move?
Move, Presiding Officer.
Thank you. The question is that amendment 307 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. Point of order, Martin Whitfield.
I'm unsure if my vote's actually been registered. I would have voted yes.
I can confirm that your vote was recorded, Mr Whitfield. Thank you. The result of the vote on amendment number 307 in the name of Pam Duncan-Glancy is yes 47, no 60. There were no abstentions. The amendment is therefore not agreed. And I call amendment 308 in the name of Pam Duncan-Glancy, already debated with amendment 306. Pam Duncan-Glancy, to move or not move?
Move, please, Presiding Officer.
Thank you. The question is that amendment 308 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 308 in the name of Pam Duncan-Glancy is yes 47, no 59. There were no abstentions. The amendment is therefore not agreed. I'll draw bill proceedings to a close this evening. At that point, I have one further item of business, which is consideration of business motion 19023 in the name of Graham Day, on behalf of the Parliamentary Bureau setting out a business programme, and I call on Graham Day to move the motion. Thank you, Minister. No members asked to speak to the motion. Therefore, the question is that motion 19023 be agreed. Are we all agreed? The motion is therefore agreed. The next item of business is decision time. There are no questions to be put as a result of today's business, and I close this meeting.